Hi, everyone. I'm Veronica Vargas Stidment, Executive Director of the Center for Women in Law. Welcome to today's installment of the Center's Ex Libris series, which hosts discussions with authors and their timely and relevant new books. We're very excited to welcome Linda Greenhouse to discuss her new book, Justice on the Brink, and to be joined by our conversation host, Professor Steve Vladeck. I'm very excited that we're joined by colleagues from across the country. We have folks from West Virginia, Hawaii, and everywhere in between. So if you want to drop us a quick note in the chat and let us know where you are today. A little bit of housekeeping. Today's event has been approved for 1.25 hours of CLE credit by the Texas State Bar. If you're watching us in Zoom, you will receive an email this afternoon after the event with information on claiming your credit. If you are joining us by phone, please let us know that you attended today by sending an email to Center for Women in Law, and that's all one word, Center for Women in Law at law.utexas.edu. And during today's discussion, feel free to post your questions in the Q&A. For those of you joining us for the very first time, the Center for Women in Law is a national resource and champion for women lawyers, generating lasting change within the legal profession. We pursue our mission in a variety of ways, including programs like today's Ex Libris event, which is made possible by the support of our sponsors and donors, including many of you who are watching us today. Gifts of any amount support the many programs and initiatives at the center and advance our mission, and we thank you so much for your generosity. So without further ado, let's meet our author and our conversation host. Linda Greenhouse is a senior research scholar and lecturer at Yale Law School, but many of you may know her byline and recognize it from her 3 decades as Supreme Court correspondent for the New York Times. Since 2010, she's written a twice monthly op-ed column for the Times about the Supreme Court. And during her career, she has received numerous journalism awards, including the Pulitzer Prize. So thank you, Linda, for joining us.
Oh, my pleasure.
And we also are joined today by Professor Stephen Vladeck, who holds the Charles Allen Wright Chair in Federal Courts here at the University of Texas School of Law. He's a nationally recognized expert on the federal courts, constitutional law, national security law, and military justice. He's argued dozens of cases before the U.S. Supreme Court, the Texas Supreme Court, and various lower federal and civilian and military courts. You may have seen him recently testify before Congress. He's also the co-host, together with Professor Bobby Chesney, of the award-winning National Security Law podcast. He's CNN's lead Supreme Court analyst, and you may also recognize him from the podcast he hosts with his wife, Karen, who's a law firm partner in Loco Parentis. And many of you know that Karen moderated a panel for us this summer, so it's becoming a bit of a family affair. So Steve, maybe your daughters will join us several years from now too. So without any more comments from me, I'm going to let you all talk about this great book.
Thanks, Ronnie.
Before Steve begins, can I just thank him for doing this? Because, you know, I think I'm busy, but Steve, you are the man of the hour with everything you have on your plate. So I really appreciate it.
No, this is a treat for me, and I'm so glad that we have such a good audience for this. So, but before sort of I ruminate on my daughter's going to law school in a few years, Linda, I guess where I want to start is why this book and why now? I mean, you announced, I think, in December that you were ending your tenure as a regular columnist on the Supreme Court for the Times. What impelled you to write this book and to do it when you did?
Okay, well, to be perfectly honest, what impelled me was an offer I couldn't refuse from Random House. So wonderful editor at Random House, David Ebershop, had the idea that this was back in the fall, shortly after Amy Coney Barrett was confirmed to the court in October of 2020. His idea was, hey, we've now got 3 Trump-appointed justices on the Supreme Court. What is going to happen? This figures to be a very consequential turning point in the history of the Supreme Court. How'd you like to write a book about it? So the plan that emerged from this conversation was basically to chronicle the October term 2020 of the Supreme Court in real time, Every chapter is a month, and I wrote it in real time. And as I say at the end in an author's note, I did not then go back and sort of clean up my first impressions and make myself look smarter than I was in my responses to arguments and so on. I really couldn't have done that because Random House's idea was they wanted to bring it out this fall as close as possible to the first Monday in October 2021. For any of you who have written or known anybody who's written a book, that's an enormously fast turnaround time. So I turned it in chapter by chapter. They edited it chapter by chapter.
So when you started, I mean, I guess that I want to ask, did you have any sense when you started writing the book just how, for lack of a better word, insane the October 2020 term of the Supreme Court was going to be?
Well, I mean, speak about insanity. So let's go back to the night that Justice Ginsburg died, September 18th, 2020. I mean, that was insane. I mean, it was very sad, of course, but what was insane about it was Mitch McConnell announcing that Donald Trump was going to fill the vacancy. I mean, the election of 2020 was already in progress. Millions of Americans had started to vote in early voting. And that was just a head-spinning development. And then, of course, without expecting to write a book, I watched the so-called confirmation proceeding and so on. So I did have a sense that something norm-breaking, I mean, really unusual, and from my point of view, very disturbing, had occurred. What I didn't know, of course, what I didn't imagine is that within a couple of weeks of Amy Barrett coming on the court flipped in deciding which was more important, a religious worship service indoors or public health. Because as you know, as people know, when RBG was still alive, the court had upheld COVID-related public health measures that limited the number of people who could gather indoors for worship or for anything else. And the first case that came back to the court after Amy Barrett was sitting was the case from New York, and the court flipped 5-4. So that was certainly a signal that we were entering new territory.
So I guess I want to keep on with the Justice Barrett theme for a minute, because obviously her confirmation is such a looming omnipresence over the term. What's your sense of how her confirmation has changed the internal dynamics on the court? I mean, obviously, the most visible thing to me as a court watcher is how much it marginalizes Chief Justice John Roberts, right, who famously during the October 2019 term is in the middle of everything, right, is the swing vote. And now all of a sudden, as in the Roman Catholic diocese case you just mentioned, he's now joining the 3 remaining Democratic appointees in dissent. So in addition to sort of her vote versus Justice Ginsburg's vote, do you have a sense of how it's affected the way the court is doing its business?
Yeah, I mean, the first chapter in the book actually is not a month-by-month chapter. The title of it is The Triumph of John Roberts. And it's a look back on the 2019 term for exactly the way you say. And I'll try to answer your question, but let me just mention something that has struck me about this, is the irony of Chief Justice Roberts' position. Because if you go back to November 2016, had Hillary Clinton been elected president, she would have filled the empty seat that McConnell had been holding empty, not allowing President Obama to fill it with Merrick Garland. She would have filled that seat, and John Roberts would have been rendered irrelevant because there would have been 5 liberal justices to his left. Fast forward 4 years, and just as you say, he's rendered irrelevant because now there's 5 justices to his right. I mean, who could have imagined this, really? So, I never like to pretend to know more than I know. I'm not clued into the, deep recesses of internal dynamics on the court. But, certainly it's a new world. And there's a permeable barrier between the court and the rest of the world, obviously. And I think, if anything, the 6-3 majority now has changed the ecology in which the court operates. That is to say, it's emboldened litigants who think now's their chance. We've been waiting a long time for this. We've been waiting since Robert Bork was defeated in 1987, and now we finally have the court. And so I think one thing that exemplifies that is the Mississippi abortion case that's pending, because when Mississippi filed its petition from the Fifth Circuit opinion, which of course had struck down the 15-week abortion ban, having no choice because there's obvious settled law on that. Mississippi filed a cert petition. Ruth Ginsburg was still alive. The cert petition came in early in the summer of 2020. And they were not asking the court to overturn Roe. They were making various arguments about why their law should be upheld, but it had a kind of a modest frame. I mean, those of us who understand what game was afoot saw through that, but for public consumption, at least, it had a kind of a modest frame. So the court grants the case after, I write a lot about this in the book, actually, after many, many conferences in the winter and spring of 2020, 2021, before deciding to grant it and how to frame the question. And then Mississippi comes in with its merits brief saying, oh, by the way, overturn Roe, overturn Casey. And that's because they knew they had the votes.
Right.
They absolutely, and so that's just a window into what I think is going on in the larger world that surrounds the court.
So I want to sort of follow the frame of the book, which really does unpack the term chronologically. I mean, you've already mentioned that the most immediate impact Justice Barrett had was in these emergency orders in these COVID religious liberty cases, and that would, of course, keep up throughout the term. But of course, even before she's confirmed, the court is confronted with a whole bunch of election cases. And I guess I have this, it's outsider view of the election cases where we saw a court that was very ready to be very active, and in some cases was very active in the months and weeks leading up to the election. And then after the election, did everything possible to not touch the election with a 10-foot pole. Is that your assessment as well? And I guess, where do you see that fitting into the story of the term?
Yeah, I think it's easy to sort of over-interpret that. Objectively, you're right. But I think that the cases that came to the court after the election were just so wild and woolly that it would have been pretty remarkable for any court to want to take them. Now, I think Justice Alito was very interested in taking some of these, but he realized that it was not the moment. The moment had passed. But these justices managed to plant little seeds. I mean, the thing that I'm sure you're watching and all election law informed people are watching is the rise of this state legislative supremacy theory that the court has never had 5 votes for. It had 3 votes for it in Bush against Gore, and I think it may have 3 or 4, or who knows, maybe 5 votes for it now when the case is presented properly. And the context for this, and you'll correct me if you don't think this is right, what's driving this great sudden interest on the right in the powers of state legislatures to unimpededly control election rulemaking is that, of course, all state legislatures are heavily gerrymandered. And in the swing states that were at issue in the 2020 election, these legislatures were gerrymandered in favor of Republicans. But because a lot of state Supreme Courts are elected, and of course the justices run statewide, they're immune from gerrymandering in that sense. And so you have states with Republican legislatures and either Democratic or, not necessarily on the conservative bus, state Supreme Court justices. So the impulse is to take the power away from the kind of things that the Pennsylvania Supreme Court did, for instance, in expanding the number of days in which mail-in ballots would be counted, and various COVID-related amendments to the existing election law. And that was pretty infuriating to a certain side of the street. And how do you get around it? You read the Constitution as saying, well, it's just up to the states. The state legislatures can do whatever they want. And of course, we're seeing that play out, big time in the power grabs that are going on now in the state legislatures.
Yeah, I mean, it's a remarkable argument. I mean, the independent state legislature doctrine, at its simplest, is the idea that when it comes to federal elections, a state Supreme Court doesn't actually have the last word on the meaning of state law. And I guess, I may be a simpleton. I would have thought that an interpretation of the federal Constitution that restructures the supremacy of different state actors as a matter of state law might have sparked some, dissent in 1787 or anywhere along the way if that had been in vogue.
Well, yeah, I mean, I think, it grew out of, in Bush against Gore, the Florida Supreme Court was acting very aggressively and not buying what the Supreme Court in the first of the Bush against Gore cases, the Palm Beach County case, was trying to nudge them. And we've got this, and just because there were not 5 votes for it in the fall of 2020 does not mean that this doctrine has died. It's just been fertilized and it's growing underground. And that's why I said I don't take the court's kind of quiescence post-election day as anything other than we're biding our time and we're waiting for a better set of cases.
So, I mean, that's an interesting segue to the next question I want to ask you. I mean, I think, when folks look back at the October 2020 term, obviously the Barrett confirmation is a centerpiece. The elections and the sort of the resolution of the election is a centerpiece. Do you have your own sort of Linda Greenhouse view of what the other biggest developments were at the court, looking at the term as a whole?
Well, there were cases, merits cases, that I don't think have received really enough attention. I'll mention 2. One is the takings case, the Cedar Point case, which really, and I say in the book, was Justice Scalia back from the dead. It's a vindication of what Scalia was trying to do and never quite could get it across the goal line to kind of meld the regulatory taking and the absolute taking, and any little incursion, as in the Cedar Point case, which people remember was a takings challenge to a California law that allowed union organizing of farm workers on the property for an hour, I think it was, before the workday and an hour after the workday. The theory being you couldn't really contact or find these farm workers very easily after the workday. And so the union organizers were enabled by this law to go on private property, which sounds like, if anything, if a taking at all, certainly a regulatory taking. But the court, struck it down in absolute terms. And that's really a turning point in property law, which I don't claim to be an expert, but Justice Breyer's dissent in that case pointed out, what about the kind of inspections that governmental agencies undertake as a regular matter? Are these all takings because you spend an hour in somebody's place of business? So that's one thing. I mean, I was surprised how little attention Cedar Point got. And the other was the Voting Rights Act case, Brnovich, the case from Arizona, which came down on the last day of the term, an Alito opinion, which is written as if this country has no history, and a Kagan dissent that, if anybody ever wants to read a fabulous Elena Kagan dissent, I recommend that one. As everybody knows, the Shelby County case in 2013 basically got rid of Section 5 preclearance, leaving Section 2, and Brnovich takes a big whack out of Section 2 in a very, very ahistorical way. So those are the two merits outcomes of the term that I would underscore. But of course, what else was going on, and I spend a lot of time on this in the book, is what the court was doing in its agenda setting function, what cases it granted, and we can talk about that at length. So merits and cert grants are where the rubber meets the road, and that's what happened that term.
So I do want to get to, I do think that the sort of, when we look back at how blockbuster a term I think this term is going to end up being, right? The work the court was doing last term to set the stage for that's important. I want to get to that in a second, but if you'll permit me one diversion, I've also tried to suggest that two of the other cases that don't get enough attention, but that really should, were both these strange 5-4 decisions where Thomas joined the lefties. And by that, I mean the Arthrex case and the TransUnion case, both of which are these separation of powers cases. One about whether patent judges are inferior principal officers, one about Congress's power to confer standing on those who are bringing consumer privacy and consumer protection claims. And Linda, I guess without going into the weeds, I mean, do you think, I want to float a theory, which is that Justice Thomas felt comfortable dissenting in those cases because he wasn't the swing vote. Do you think those cases come out the same way with Justice Ginsburg on the court instead of Justice Barrett, and Thomas just goes with the conservatives? Those are strange votes for him historically.
Yeah, I really don't know how to answer that question, because I don't think I retract RBG's views on these issues that as closely as you have. But to me, the most interesting Thomas vote was his concurrence. I think I'm right about this in the Affordable Care Act case, where basically he said, more in sorrow than in anger, I have to agree that these states that kept trying to bring down the Affordable Care Act with this cockamamie theory just didn't have standing. And, that was pretty interesting too.
I agree. All right, the last question I want to sort of ask about the merits cases from last term. So Steve Mazie, who we both know, who covers the Supreme Court for The Economist, got into some trouble for floating the description of the court in the middle of last term as the 3-3-3 court. The idea being that the court had basically split into three justice blocks, with obviously Justices Breyer, Sotomayor, and Kagan over here, Justices Thomas, Alito, and Gorsuch over there, and Chief Justice Roberts and Justice Kavanaugh and Barrett in the middle. And I guess I'm curious what your reaction is to the sort of the 3-3-3 framing of the post-Barrett court.
Yeah, well, it makes me kind of nostalgic because during my reporting days at the end of every term, the convention was you had to wrap up the term and say, how conservative was it? How surprising was it? How this, how that? You had to label it. And, I'm sure I played that game too. And, I think there's an impulse now to kind of label the emergence of whatever the Roberts Court is going to become. And I understand that impulse. And, I struggled with it a bit at the very end of the book. You'll tell me, I think I navigated it without, affixing that kind of label on it. You can pick out cases that would sustain that, but I think there's more cases that don't.
Yeah.
Take a look at what's been going on with the SB8 case. Your audience knows that case. So here we are on September 1st, and the providers are simply asking for a stay, and a stay would have been the absolute regular thing to do, because of course, aside from the weird jurisdictional questions, the question of banning abortion at 6 weeks relates very closely to the Dobbs case, which was cert granted and argument set, banning abortion at 15 weeks. And so typically the court would just put a hold on a case that was going to be, the merits of which were going to be determined by a granted case. And, so where were the other three other than Chief Justice Roberts in that? And that's a very telling moment, I think. And so it's really hard to sustain the 3-3-3 when two of the middle three behaved the way those two behaved in that case.
So I'm glad you brought up SB8 because, I was struck in looking back at the end of the book last night that, you signed the sort of the afterword. I think it was August 13th is the date of the afterword. And of course, I mean, for the obvious reasons, that was when the book had to be put to bed. But the term carried on. And I'm curious if you would have said anything differently about the term as a whole if the SB8 ruling had come in time to include it.
Oh, sure, I would have. I mean, I think the first line of my May chapter, which was the month in which they granted cert in Dobbs, I think the first line was, it was always about abortion. And of course, because all we had that term was a cert grant, we didn't have an actual vote. And of course, we don't know what happens behind the black curtain in deciding whether to grant cert. So yeah, I mean, the behavior in the SB8 all the way through and up through and including what the game the Fifth Circuit is playing, which many of our audience know about, I'm sure. Yeah, I would have, had to gone pretty heavy on that.
So I guess the last question I wanted to ask about that before turning to what's on tap. I mean, you've covered the court for a long time. You have seen a number of transitions. You have, gotten to know so many of the justices. And I guess I'm just curious, if Justice O'Connor or Justice Kennedy or Justice Souter were inclined to give public statements still about the court, or even to speak privately about the court, do you think they'd be surprised by what they're seeing?
I think Justice O'Connor would be kind of heartbroken, actually. And she had made some remarks after her retirement because, Justice Alito coming to replace her, that was a major turn. That was one of the more consequential swaps of a Supreme Court seat in the last half century, I would say. and she made, so, her vision, and, Justice O'Connor was criticized in the legal academy for not having a kind of a, doctrinal purity one way or another. But, she was basically a politician in her prior life. And she saw her role, I think, as kind of holding it together, certainly in the free exercise establishment clause area. Her writing, I think, was very sort of cognizant of, not being too categorical on one side or the other. And so I think she would be really, really sad. Justice Souter, I think, would also be pretty heartbroken. Justice Kennedy, I don't know. It sort of depends on which side of the bed he got up on a given morning, because, there's the Justice Kennedy of liberty, and there's the Justice Kennedy who concurred in what I think was his last vote.
Yeah, the travel ban.
In the Muslim ban case, one of the most pathetic. I mean, truly. I mean, I think I'm not just importing my view of the merits, although of course I am. But if you read that opinion, it was just so lame. It was like a tired old man saying, I think something's wrong here, but I just don't have the energy to identify it. So I'm just going to give the Chief Justice my fifth vote, and I'm done. I'm out of here. He announced his retirement that afternoon. So I wouldn't speak for Justice Kennedy, but I think the Justice O'Connor, of course, she's still alive, but in full dementia. Justice Souter's alive and well. I haven't spoken to him for a long time, but I'm sure he's pretty sad.
Do you think, I mean, I can't resist asking one more question before we get to this term, which is, I mean, while all of this was happening, there was as sustained a public conversation about Supreme Court reform, certainly as has happened in my lifetime. And of course, we know that effort largely fizzled, that the much ballyhooed Supreme Court Commission issued a fairly anodyne report. And I guess I'm curious from your perspective whether all of that was inevitable, or whether maybe there was a missed opportunity for, building consensus around reforms that were short of the big ticket items of adding seats to the court, of imposing term limits, and so on.
Well, I think you have to look at it, in a kind of realpolitik way. And so, given, there was a lot of excitement when it seemed that the Democrats might have a workable majority in the Senate, going into the 2020 election. So, I wasn't surprised that nothing much came of it, but I'll push back actually against the kind of fizzle analysis. I think it was a really useful exercise. I think the testimony that you and others gave about, what is it that we expect from the court? What is the court's role? What are the issues here and how we think about the court? Nico Bowie and Sam Moyn on the one hand, and the sort of, I might say, without meaning any disrespect, the old guard on the other that still has hope for constitutional law, right? It's fascinating. And, that it didn't kind of, quote, lead to anything in this very weird moment and year that we're in. I think it'll, stand as a kind of a record on which people can build as times change going forward. I think it was a valuable exercise.
So I'm glad you mentioned Nico. I mean, I think Nico's testimony, if folks want to find one thing to read besides your book, coming out of our conversation today, I would encourage them to go find Nico Bowie's testimony before the Supreme Court Commission. I guess the other piece of that is, I wonder if it's your sense, it is mine, that there is much more willingness on the part of academics, those who are, more involved in actual practice before the Supreme Court, to be publicly critical of the court, of the justices these days, and maybe it was true as recently as 10, 15 years ago. Do you think that's related?
Oh, I think it's fascinating, actually. For people who are interested in sort of the evolution and history of the academy, it's really interesting. I mean, what I perceive is almost is a generational shift. I think the old guard, that's say sort of my cohort, who grew up in the shadow of the Warren Court with the notion that, the court is one of the major forces for good in our country, and the Constitution can be seized as an engine of progress. People have a very hard time detaching themselves from that reading of the Supreme Court's role, even though it's kind of an ahistorical reading.
Right.
That's not the court's role in the long run of U.S. history, but it was, such a dramatic period. Whereas the younger crowd grew up in the Burger Court, Rehnquist Court era, and that's a very different kettle of fish. But even within the younger crowd, I guess I mean people younger than like 70, because some of these people, Sam Moyn I think is 50, and he's he's very out there on the Nico Bowie side. Within that crowd, there's a dichotomy between those who, like Noah Feldman, are still trying to make nice to the court because they want their students to get clerkships. I mean, I shouldn't use the word sucking up in such polite company, but yeah. And then those who, are trying to be austerely analytical about what they actually think and are willing to say it. So I think that's an interesting difference too.
So I guess I'm people are gonna get this is gonna sound like a broken record, but one more question before we get to this term. So in that regard, I mean, I'm curious. Something else happened in September, obviously after the book went to print, that I'd love your reaction to, which is the Justices Speaking Tour. Right, we had these remarkable public speeches by Justice Breyer, by Justice Barrett at the McConnell Center, by Justice Alito at Notre Dame Law School. Each of the speeches was different, right? But I guess it was it seemed like it was a, we're really not the partisan hacks you keep calling us tour. And I'm curious if you think that those speeches were unusual in historical context.
Yeah, I do. And I actually wrote a column about it in the Times. Maybe if someone can find it, they could put it up in the chat, where I analogized that speaking tour to what happened in the immediate aftermath of Bush against Gore, when justices were going out around the world, not just the country, saying, we're okay, we're still a court, we're okay. So yeah, I think they were so clueless in what they did with SB8 at the beginning of September that they were shocked by the public response. The polling indicated that public approval of the court, plummeted by like 15 percentage points in the immediate aftermath. Now, correlation is not causation, but it was very dramatic. And I think, as I'm sure it's occurred to you, Steve, one thing that Justice Alito was alluding to in his Notre Dame speech was your work on the shadow docket, your criticism of the shadow docket.
Not just alluding, he called me out by name.
Okay, call you out by name. That's even better. That's a badge of honor. You've, for people on this call who don't follow Steve Vladeck's every move, the fact that the court eventually actually granted plenary review in the beginning of the SB8 case, and had argument in the emergency applications in the 2 vaccine cases, which certainly were shadow docket cases if there ever were any. I think it's a response to the criticism that was sparked by you. So yeah, that speaking tour was interesting on many levels, but it certainly said to me that the court is attuned to what the public is thinking and saying about it.
And indeed reading its own press, which I think, you've obviously known for years that the justices do this, but I think folks might be surprised at the extent to which some of the justices are very aware of what is said about them publicly.
Yeah, some are, and some don't care.
Yes, and folks could probably guess who is who.
I think some, revel in being criticized by the mainstream media. I don't know, I don't purport to know, but you're right.
So I put into the chat at Diane's request and at Linda's suggestion both a link to Professor Bowie's testimony and a link to Linda's column reacting to those speeches for folks who want to access them. The links are in the chat. So Linda, I do want to turn to this term because it seems like you could also write a book about this term. It would be longer, I think. And I guess I'm not even sure where to. I guess the best place to start is Dobbs, but I wanna sort of extract from there. But so with Dobbs, I was struck by the tenor and the tone of the oral argument, and the sort of the complete seeming indifference on the part of everybody except Chief Justice Roberts at some kind of middle compromisey type of decision. I guess I'm curious, did you share that reaction? Did you have other sort of thoughts after the argument in Dobbs?
Yeah, I didn't actually, responding to the way you phrased that, I didn't see the Chief Justice as being all that open to compromise. Well, let me put my view on the table,
Please.
Which is that there's no way the court can uphold the Mississippi law without overturning Roe and Casey, whether they overturn them explicitly or whether they overturn them functionally and try to gaslight the public and not acknowledge what they're doing, because the viability line is the firewall that has existed to protect the right to abortion since Roe, reaffirmed in Casey, which recognizes the state's ability to protect unborn life from the moment of conception, says, yes, you can have required counseling, you can have waiting periods, you can make the woman jump through all kinds of hoops. But at the end of the day, before viability, she has the right to terminate a pregnancy. So there's no way around that. And so to the extent that Roberts, during the oral argument, was kind of pushing back against, well, where's this viability thing come from anyway? Harry Blackman was, very dismissive of it. Well, really? I mean, like he wrote the opinion. So I was surprised by that. I don't know what they thought, people were going to think of that. And of course, what really grabbed me, and I think many other people, was Amy Barrett's remarks. So to contextualize those, so the part of Mississippi's argument, right? So you need some kind of reason. The stare decisis doctrine tells us you need some kind of reason if you're going to overturn a precedent. So what could possibly be the reason that a state could articulate? So Mississippi says, well, at the time of Roe, it was considered important for women to be able to control their reproductive lives in this way because women didn't have, much of a purchase on, the economy, and they didn't have much, power, and so on and so on. And now women are everywhere, and so women don't, need that need that safety net. So what Amy Barrett had to say is, she said, the fact of having a baby is not really all that onerous because, of course, you don't have to keep the baby. You can put the baby up for adoption, or you can, under the safe harbor laws that apply in every state, you can leave the baby. She didn't quite say that. I'm not putting words in her mouth. Leave the baby in a basket in a safe place as specified by those laws, a firehouse, a hospital, a police station, and you won't be charged with child abandonment. So, just because you can't get an abortion and you have a baby doesn't mean that you have to be a parent. Well, I mean, for those of us who are parents, the notion that once you've had a baby, you can just sort of wash your hands of it and not consider yourself ever to have gone through that experience. It's just, when the argument was over, I had to get up and take a walk and get some fresh air because I just found that astonishing, let alone coming from, a woman who has given birth to 5 children. So that's where we are.
Do you think there's any way Roe and Casey survive this term?
I don't think so. I don't see how. They might play around with the viability moment. But, if they uphold a 15-week ban, and what's, as justices often say to counsel on the bench, what's your limiting principle? What's the limiting principle? Viability is an obvious limiting principle. 15 weeks, 10 weeks, 6 weeks, like in SB 8, 0 weeks. I think Arkansas has a pending bill for like 0 weeks. That's the ecology. When I mentioned ecology before, now the states are just getting so excited about their opportunities. So I don't see how they explain it. But presumably a vote's been taken and draft opinions are circulating right now, and I guess we'll see.
I guess I'm curious. Obviously, whatever the court does in Dobbs will be one of the headlines of the term. I think the SB 8 ruling, the merits ruling on December 10th is going to be a headline. What do you expect, are going to be some of the other most important cases we're going to hear about and see between now and the end of June?
Well, the Second Amendment case from New York, the gun rights case, which was another of the cases that the court granted during OT 20 that I write about. This is the wish fulfillment of the Thomas Gorsuch Alito crowd who've been complaining that, Heller was back in 2008. We haven't gotten back into Heller. And now they don't much like Heller because Heller was, really very narrow. If you read it honestly, it just gives you the right to keep a handgun at home for self-defense. But the New York case is the right to carry a concealed weapon, walk it around the street, and what kind of licensing regime does the Second Amendment permit? So just to briefly touch on the facts of the case, every state has some kind of license regime for carrying a concealed weapon.
Although we're working on getting rid of ours.
Oh, okay. Yeah, no, Texas is doing really well with gun violence. That should be very encouraging to everybody. So New York is, and about a half dozen other states are kind of outliers that require for such a license not just the usual proof that you're a law-abiding citizen who knows how to handle a gun, but that you have a special need to carry a concealed weapon. There's something about your situation that distinguishes you from the mine run of the public. And so that's the challenge here, that the Second Amendment doesn't permit the state to set such a high bar. And so it's the post-Heller case that everybody's been waiting for. There's other cases in the wings also that the court's sitting on. And, we've been quiet on the Second Amendment for a long time because there were not a reliable 5 votes. And I guess the grant of cert here has to mean now there are, and we'll see.
So I guess I want to get to some of the stuff that we might not get in time for this term, but where would you put the vaccination cases in a sort of assessment of the coursework? I mean, the posture is very unusual, as you mentioned. These were oral arguments and per curiam decisions on emergency applications. I think the first time the court had heard an argument on an emergency application since 1970. The decisions have enormous practical effects. The decision on the OSHA rule effectively kills the OSHA rule. The decision on the CMS mandate probably means the mandate's going to go into effect nationwide. How should we think about? I mean, how were you surprised by those rulings, and how big a deal do you think they are, both practically and for the court?
I wasn't surprised. So I wrote a column the other day about what I think was really a foot there. People, you can maybe put it up in the chat. I think the significance is, yes, of course, the practical effect on the vaccine, but my argument is it's a lot more than that. Looking at the OSHA case, it was the target of opportunity walking across the stage to take a big whack at the administrative state. And I think you could argue that this major questions doctrine that we're now hearing so much about, if, as Gorsuch kind of mysteriously says in the separate concurring in full, but a separate concurrence for Gorsuch, Thomas, and Alito, says 6 of us accept the major questions doctrine. Well, the other 3 didn't object to that characterization, so let's assume they do. I don't see how that does not functionally overturn Chevron, actually. I'd be interested in what you think about that. So, that's a very major thing, because the so-called major questions doctrine, which came out of the blue with a very phony origin story, that I explain in this column, is a huge invitation to judicial activism. Because what is a major question? It's in the eye of the judicial beholder. And it just is an invitation to the court to, take agency authority and transfer it to the justices themselves in defining the scope of the agency's statutory authority. So I think it's a very big deal.
So I posted a link to your column in the chat. I also posted, I wrote a piece for the Washington Post's Monkey Cage blog about what to me is a separate but equally important feature of the OSHA ruling, which is the court once again being comfortable second guessing government motives, and the sort of, justices basically putting themselves in the positions of policymakers, which of course harkens back to the Lochner era, and the notion that we're not going to defer to decisions we disagree with, which of course begs the question in some pretty fundamental ways, much like the major questions doctrine does.
Oh yeah, I mean, the Lochner River is running right through this court, certainly on the First Amendment. I mean, not in the immediate last term, but what we've seen, the Lochnerization of the First Amendment, and yeah, absolutely, it's a very big deal.
So I have 3 more questions of my own, and then I want to turn to some of the numerous questions we have from audience members in the Q&A and encourage folks to post more. So first, obviously we got a big decision from the court last night in the Trump versus Thompson dispute. This is the effort by former President Trump to prevent the National Archives and Records Administration from turning over, I guess it's these 4 tranches of presidential records to the January 6th committee, records over which President Biden declined to assert executive privilege. I was not surprised, Linda, by the decision, even from this court. I mean, it was a pretty long shot argument. It was a very thorough decision by the DC Circuit. I guess I'm curious if anything stood out to you about what the court did last night.
Yeah, I wasn't surprised either. Given that how the court responded, of course, with Ginsburg still on the court back in 2020 on Trump's effort to shield his personal financial records. The court didn't give him that. So no, I thought this was a pretty cut and dry case. What was interesting about it was the way the per curiam was written, and then the Kavanaugh separate opinion. I mean, talk about dicta, but so what the per curiam says is we're not getting into the question of whether the fact that the incumbent president waived executive privilege on these documents produced by the former president. We don't have to get into that because the DC Circuit, and it's a really good opinion by Patty Millett, I recommend people take a look at it, said it really didn't matter whether this particular claimant was arguing in the capacity as a former president or an incumbent president. The claim just doesn't bear weight when you weigh it against the compelling need for this information that's been shown by the congressional demand. So the one paragraph per curiam sort of, dodges that bullet, and that's all they need to say. I mean, that's a fair reading of the DC Circuit's opinion. Kavanaugh goes on for a page and a half, speaking for himself, saying, I just want to underscore the fact that we're not deciding that question. Well, I don't know what he was doing, so I thought that was kind of weird in an interesting, weird way. And of course, we have Justice Thomas, who's the one dissenter, and all he says is he would grant the application,
Right.
that is the application for a stay, without bothering to inform us as to what his problem was. So.
I tweeted about this morning. I think there is this interesting dichotomy that I guess is not that surprising in retrospect between how Trump's policies fared in the Supreme Court, which is to say pretty well, and how Trump's more personal disputes fared in the Supreme Court, which is to say not well at all. And I wonder if that's like a sort of Trumpism versus Trump distinction that might not surprise us given where we are.
Yeah, I mean, that's interesting. I'm not sure what to make of it. I think it may be, well, maybe it's not premature in the fact that the personal Trump things are going to go away. Well, maybe not. It depends on, what happens. But as I said earlier, I think it's hard to draw too many lessons from the handling of the election cases. The tax case, Mazars, was just a bad case from Trump's side. So I don't know. I take your point, and it's interesting, but I wouldn't actually take much of it to the bank.
Fair enough. So two more questions for me. The first is, there are these two affirmative action cases that the court has now relisted, I think, twice. One involving Harvard, one involving the University of North Carolina, with regard to challenges to race-based affirmative action in both public and private universities. Do you think the court is likely to grant these, and that the relists are just so that they'll be pushed to next term?
Oh, no, I guess I don't see relisting as efforts to manipulate the document. Maybe I'm just naive. I think there was an effort when the court kicked the case down the road and asked for the Biden administration's views, which was completely unnecessary. But no, will they grant? I mean,
right. What would the Biden administration say about race-based affirmative action? I wonder.
Exactly. And of course, if the court grants, the Biden administration will certainly come in with a brief,
right,
and request to argue. So they hardly needed the views, on cert. And on the one hand, these cases are irresistible because, of course, affirmative action has been hanging by a thread since the second Fisher case, and that was only Justice Kennedy. So you might say, yeah, like, what are they waiting for? Well, the North Carolina case is, if I understand it, is a petition for cert before judgment. The Fourth Circuit hasn't even ruled, so that's, a little tricky. The Harvard case, I would, if I were an anti-affirmative action person advising the court, which of course I'm neither of those things, I'd say wait for the next case, because the Harvard case is not a really good vehicle. For one thing, there was a 2-week trial. There's a huge factual record that sort of gets beyond the sound bites, and it's not really an affirmative action case. So they may not be able to resist. That may be what the realists are about. They're kind of, the anti-affirmative action side is trying to sort out what's in their strategic interest in terms of managing the docket. But they have to know there'll be more of these cases because there's huge amounts of foundation money going into support this kind of litigation, and it's all over the place. Again, the ecology says to potential litigants, now's our chance. So I guess chances are they're going to grant, but I wouldn't be shocked if they don't.
Fair enough. All right, and then my last question before I turn to the audience questions. I can't resist asking you about Maskgate and the storm of controversy over Gorsuch not wearing a mask on the bench and Sotomayor participating from chambers. Is this all much ado about nothing?
Well, of course, I don't know anything other than what I read, but no, I don't think it's much ado about nothing, because when the two justices, Gorsuch and Sotomayor, put out this statement yesterday saying, actually, we love each other and there's no problem. What it didn't say is, why is he not wearing a mask and why is she hearing arguments from her chambers?
Right.
I mean, that's the question. Why is he not wearing a mask? And I don't want to characterize him, so I won't. But I mean, that's the question that needed answering. Not, do you make nice, as you're walking into the conference room?
Right. Are you guys capable of exchanging friendly words with each other? Is not really the matter in dispute in this story.
Correct.
Right. All right. So I do want to get to some of the audience questions. So where do I start? So there are a couple of questions in here, Linda, about New York Times versus Sullivan, and the sort of the suggestions from Justices Thomas and Gorsuch that the court potentially revisit Sullivan. I think there are a couple of cases in which the court called for a response on the issue. Can you say a bit about what Sullivan is, why it's important, and sort of where this might be going?
So, of course, Times against Sullivan constitutionalized the law of libel. And I think Gorsuch's beef or Thomas's beef maybe isn't so much with Times against Sullivan itself, but the succeeding cases that kind of broaden the category of libel defendants who can invoke a public figure privilege. So do I count 5 votes for doing something that dramatic? I mean, given what's going on at the court, who am I to say there aren't 5 votes? But I wouldn't offhand anticipate it. It seems to be a conversation that's going on among different denizens of the far right. I could be wrong, but I haven't actually invested a whole lot of emotional energy in it because I don't actually see it going anywhere.
There are a couple of questions about some folks on the left's favorite topic, which is when will Justice Breyer retire? I guess to put the question more open-endedly, I guess, the question I want to ask you about Justice Breyer said something in one of his interviews about how he has no intention of dying on the bench. And I guess that comment struck me, given, of course, the frame for your book, the foil for your book, the thing that, the reason why your book exists, which is that, I don't think Justice Ginsburg had any intention of dying on the bench either. And I guess I'm curious if you are surprised at Breyer's at least public disposition toward these questions, if you're surprised that he hasn't announced he's retiring yet, if you have any thoughts about what might happen.
I've kind of resisted trying to psychoanalyze Stephen Breyer. It'd be extremely presumptuous of me. Historically, justices have been really reluctant to retire. It's a very nice job. And I think in Breyer's case, the more people have beaten him up on it, including some, denizens of the Harvard Law School, the harder it becomes for him to do it, because the more political it looks. And his whole project now is to try to insulate the court from looking as political as, let's say, it really is. He's an example of the generation I was talking about a while ago, who, he clerked on the court in the Earl Warren days, right? He clerked for Justice Goldberg. And so I think it's hard for him to detach from trying to preserve at least the penumbras and emanations of that legacy. And I think people have made a strategic mistake to put these, Breyer retire posters up on their sound trucks and drive around the court. I write a little bit about this in the book. But other than that, I really don't have much to say about it.
A topic we touched on a little bit, and there's a question in the chat about it, is the sort of the evolving law of religious liberty with this court, especially with this majority. We saw flashpoints, obviously, last term with the COVID cases with Fulton. But of course, the court had this case this term from Texas. In fact, the Supreme Court clinic here at UT was involved in it, Ramirez versus Texas. Texas, yeah, right. About the sort of religious beliefs and the execution chamber. And I guess I was struck, Linda, during the oral argument at the extent to which several of the justices were seemingly openly questioning the sincerity of the petitioner's religious beliefs. Do you think that's going to show up in the decision? Or do you think that's just sort of inartful questioning?
No, I think it's really interesting. I also wrote a column about that case. It's a clash between two imperatives for the conservatives. They certainly love the free exercise clause. On the other hand, they really don't like capital defendants who are trying to avoid execution. So this is kind of where those two things meet, and it presents them with a nice dilemma, which makes the case so interesting. But there's a couple of other, real religion cases, including one the court took just this week, Kennedy against Bremerton School District, I think is the name of it. So Coach Joe Kennedy, the praying coach, who's kind of a martyr on the Christian, talk show circuit, when he was a high school football coach in this school district in the state of Washington, would pray after every game on the 50-yard line, surrounded by his players, all kneeling in prayer, and members of the community be invited. So, every football game became a big prayer session, and he was told to stop doing that. And he said, "I won't stop, it's my religion," and he was fired. And this case has been kicking around for years. It was up on cert a couple of years ago, and Justice Alito wrote a dissent from the denial of cert, and inevitably it was going to get granted. And now it's back. So I think that's a pretty big case. What are the limits of an individual employee's claim? It kind of sounds in the employment division against Smith kind of part of the forest. And then they argued about a month ago the parochial school case from Maine, which goes to the question of not only can the state channel public money into religious schools, but must it as a matter of equal protection. And the court's obviously been working its way up to that holding, which really turns upside down all the parochial aid cases that were litigated in the 50s and 60s. And it's been part of, I say in the book, it's been part of John Roberts' long-term project. And we see that in Trinity Lutheran. A couple of years ago, we see it in Espinoza in the summer of 2020. And this is the capstone on that. And that's a very big deal. So, so yeah, I mean, there's just, I mean, the Roberts Court, whatever it's eventually known for in history, is going to be known for its elevation of free exercise to the erasure, to the point of erasing the Establishment Clause from U.S. reports.
So if we get a major decision in the main case, if we get a major decision in Bremerton, if we get a major decision in, because Bremerton, I think, will be argued in April. I mean, I think that's why they granted it now. If we get a major decision in Dobbs, if we get a major decision in the Second Amendment, I mean, if we get like a conservative, just sort of white, clean slate at the end of this term, no doubt we're going to have the conversation again about the Supreme Court's legitimacy. And I'm curious, I mean, there are a couple questions in the chat about all of these developments and, the sense that in some quarters, especially the Supreme Court's popularity and legitimacy is eroding, that the court's doing very little to try to win it back. And I guess I'm curious, I mean, like, for those who are watching, who are listening, who are increasingly suspicious of the court and worried about what it's going to do, is there a note of optimism to be struck?
No, I mean, I commend to people my colleague Christina Rodriguez's foreword in the Harvard Law Review this fall. It's a very long piece called Regime Change. And what she talks about is the fact that we have two regimes at cross purposes. We have the election of Joe Biden by millions of votes, in a Democratic Congress, on the one hand, embodying a certain view of the role of the government. And then we have the Supreme Court on the other hand. And, when has there recently been a time when these two trends were at such cross purposes, at such odds? And it's a very important moment. And, if you read the Nico Bowie piece or the Sam Moyn testimony, they say legitimacy is the wrong question. We shouldn't care about legitimacy. We should care about the court doing whatever it's doing, and we should hope that it would do less. We should, stop kind of valorizing the court. We should find ways to basically disable the court from intervening in our political life. So it's the question of the moment, definitely. And that's why I think the president's commission was really so useful in providing a platform for people who are thinking deeply and care a lot about these issues to kind of give us ways of thinking about it.
I guess I want to ask you two more questions from the Q&A, and then I think one wrap-up question before throwing it back to Ronnie. And I put links, by the way, to Linda's column on Ramirez and to Professor Rodriguez's forward in the chat. So the first question, this is sort of a follow-up on the previous question about the justices' speaking tour, which is one of the things that the justices all but unanimously did was attack the press in their speeches. And as certainly a former regular member of the Supreme Court press and a continuing lurker, I guess I'm curious for your reaction on holding out the press as the enemy when you're the Supreme Court. And when you're a Supreme Court that relies so heavily on the press to communicate as it does.
Well, that's an interesting question. Of course they do rely on the press to communicate, but they have never acknowledged that to themselves. I mean, that's a real disconnect. They pretend that that's not the case. It's a pretty cheap shot, and in a way, I think it's good, because one knock on the Supreme Court press corps, so-called, which is a very tiny, kind of close-knit. I think the court only issues something like 24 press passes, unlike Congress where there's hundreds. So, it's a pretty tight little group. It had always been, oh, you're just you're never going to bite the hand that feeds you. And, you're basically, at the end of the day, just a shield for the legitimacy of the court that you spend your life writing about. So I think it's quite healthy if the justices feel like bashing the press. It shows that the press is doing its job.
So keep on keeping on. I know, on strict scrutiny, when they had Adam Serwer on, they talked about the risks of when justices call out individual reporters by name, as Justice Alito did with Adam Serwer. I mean, do you think that's just a badge of honor, or do you think there are reasons to be wary of such personalized attacks?
Oh, yeah. I mean, I think personalized attacks ought to be beneath the dignity of a Supreme Court justice. I mean, I was the quote victim of, this notion of the so-called greenhouse effect when Judge Larry Silverman of the DC Circuit, denounced me. So I've kind of worn that like a badge of honor for the last 25 years. So, we can take it. It's not something that, keeps me up at night.
Fair enough. And my last question is, so what's next? I mean, you've written your last regular column. You've written this book. You keep writing columns even though you aren't writing a regular column. I guess for folks who are fans of your work as I am, what's in store for the next coming weeks and months and years?
Oh, well, I was always going to keep writing. I mean, all I did was not renew my contract that called for me to write every 2 weeks, and that limited me from writing for other publications. So I just wanted to spread my wings a little bit. But I'm definitely still in the game. I'm still teaching at Yale. Will I ever write another book? I don't know. I didn't expect to write this one. But no, I mean, nothing all that much has changed in my attitude toward my professional life.
Cool. Any final words before we sort of bring back the Ronnie in the center to sign us out?
Well, Steve, I appreciate this conversation very much because I've done a few of these, but I have to say you bring to it. It's just fun to talk with you.
Likewise.
So I hope we get to have another dinner this coming summer up in the Berkshires.
That would be nice. Hopefully when it's not quite so cold. So everyone, the book is Justice on the Brink, The Death of Ruth Bader Ginsburg, The Rise of Amy Coney Barrett, and 12 Months to Transform the Supreme Court by the incomparable Linda Greenhouse. I hope that you will join me in at least silently clapping for Linda and thanking her for taking the time to join us today. So Linda, thank you very much.
Thank you, and thank the center.
I want to thank you both, and on behalf of the center and everyone watching, Linda, I'm glad you had fun talking about the book. We had a lot of fun listening to you both, so thank you for that. As I mentioned, this event is approved for 1.25 hours of CLE credit. If you're watching us on Zoom, you'll get an email with the details. If you're participating by phone, please email us at Center for Women in Law at law.utexas.edu, and we'll make sure that you get your credit. This has been a huge pleasure. So again, once again, big thanks to Linda Greenhouse. The book is Justice on the Brink, and to Professor Steve Vladeck for a wonderful, wonderful discussion. I invite you all to join the Center for Women in Law for future events, and to please consider supporting our mission by becoming a friend of the center. And that link should pop up in the chat soon as well. Thank you very much. And please be sure to follow us on social media so you get news about the center and about our future events. Thanks so much.